The content of this webinar is not intended to replace your firm policies and procedures, nor can it be deemed to be legal advice. You are advised to consult with your broker and your firm attorney to address the issues that are in your specific transaction. Aloha. Welcome to part 3 of HAR's first webinar online. Today we're talking about Act 66, which provides an exemption to realtors from the definition of distressed property consultant under Act 137. The exemption in this new law should not be, however, interpreted to mean that Act 137 has been repealed. It has merely been amended to exempt real estate licensees from the definition of distressed property consultant. Practitioners must understand that to the extent a distressed property and a distressed property consultant, that is someone other than the licensee, is assisting the seller in negotiating with their bank or lender, are involved in a transaction, all of the Act 137 provisions remain in effect, including all notice, rescission, and recordation requirements. On the other hand, if no distressed property consultant is involved in the transaction, then Act 137 does not apply, and the parties can close as they normally would in an ordinary transaction. Under the Hawaii administrative rules that govern the practice of real estate, however, licensees must ensure that their transactions are properly documented. The tricky aspect of our new law is that because Act 137 has not been repealed and still applies, when you have both a distressed property and a distressed property consultant, all of the special notice, rescission, and documentation requirements of Act 137 are applicable if the seller's distressed property consultant is not on the ball and does not provide the requisite documentation for what's called a distressed property conveyance contract. Then it may unfortunately fall upon the realtors involved in the transaction to ensure that documentation is complete. That's because your regulations provide that to fully protect the general public in its real estate transaction, every licensee shall see that financial obligations and commitments regarding real estate transactions are in writing, express the exact agreements of the parties, and set forth the terms and conditions of that agreement, and that copies are provided to all parties at the time they are executed. Under Act 137, a special distressed property conveyance contract must be entered into by the parties whenever both a distressed property and a distressed property consultant are involved. Therefore, real estate brokers and salespersons must monitor their transactions closely and be able to recognize whether Act 137 is applicable and that the purchase is properly documented in compliance with all applicable laws.